Good morning, everyone. I'm Gayleen Rogers Lonergan, and this is Legal Answers Just for Real Estate. So today we're going to talk about a very important topic, and we've got our fellow attorney here at the Lonergan Law Firm joining us, Charlene Brown.
Hi, Gayleen. How are you doing today?
Absolutely, I'm doing great. We're going to talk about a topic that a lot of people won't have ever heard about, but it is probably the most drastic reporting requirement that the government has put on real estate transactions in almost 40 years. In the 80s, the government came up with a reporting requirement as far as foreign transactions, and now they are concerned about money laundering. And so they have come up with a rule called the Residential Real Estate Reporting Rule. And it's going to be implemented nationwide by a group called the Financial Crimes Enforcement Network, or FinCEN. So you're going to hear the word FinCEN. Anybody in real estate is going to be very familiar with that terminology very soon. So the rule is going to go into effect on March 1st. So it's less than a month from now. And it's to prevent illicit financial activity, money laundering through anonymous property purchases. So the challenge is that all cash transactions involving an entity, with limited exceptions, will have to be reported, and the reporting is extensive. It's going to make real estate transaction closings significantly more complex. The rule applies to anyone who's involved in all cash residential transaction. Now, the issue is that all cash is defined differently under the rule than we think of. Essentially, it is any buyer that's an entity or a trust falls into this type transaction with limited exceptions.
Okay, so I have a follow-up question. Would you say more often than not, with this law going into effect, real estate attorneys such as yourself who specialize in a lot of cash transactions is more important than ever because you will be interpreting laws and legalese that lay people may not understand or know?
Oh, absolutely. Absolutely. At the very least, until this rule becomes second nature to everyone, and that will not be anytime soon. Any layman that just tries to navigate this requirement is asking for trouble, because as we're going to talk about here later, the penalties for not following it to the letter can be extensive. So this rule involves all non-finance transfers of real property where the transferee is an entity or a trust. So the transactions that are included are certain vacant land, individual units within a large, like condominium residential building, single family homes, and shares in cooperatives.
And may I ask who's required to report?
Okay, who is required to report? That is a very detailed answer as well. The rule has a list in order of who is the reporting person. Who's at the very top of the list? Settlement agents. So any title closing that's closing at a title company, unless the designation is changed, the title company, whether it's a insured transaction with title insurance or a non-insured where no title insurance is involved, the settlement agent is the responsible party to report. And that's the entity that has the liability if it is not done correctly.
I understand that not every transaction requires reporting. What are some exemptions?
Okay, there are a few that are excluded. 1031 exchanges are excluded. certain trust to trust transfers involving spouses excluded. Court supervised transfers like divorces, bankruptcy, inheritance, and judicial foreclosure. But mind you, I said judicial foreclosure. Non-judicial foreclosure, like we do here in Texas, if you sell as a trustee, like I'm often a trustee, to an entity that buys at the foreclosure sale, that has to be reported. So don't assume, you can't assume that that your transaction falls in these exclusions. Now, I want to back up a second and also say that if the transaction involves hard money lenders, that's the sticking point on these deals, because cash, we all understand about cash, right? There's no lender involved. But if a private lender or a hard money lender or any type of financing that involves someone other than a conventional lender falls under this rule.
Okay, thank you. It sounds like those who are involved should consult an attorney to ensure they follow the law. What information is required to be recorded?
It's very extensive. It's really extensive. So consulting an attorney is really, like we said earlier, is really necessary. You have to have complete details about the property and the transaction. You have to have comprehensive information about both the buyer and the seller. I mean, everything about them. Beneficial ownership information for entities. If an individual is the manager, member of a LLC, is the trustee or beneficiary under a trust, all of their information has to be included. For trust, like I said, the trustee, the beneficiaries, and on a revocable trust, the revocable grantors. Then the payment details and methods, and information about any individuals who sign transaction documents. As I recall, it's over 100 pieces of information that is required to be reporting on any transaction, and you cannot just report what you know, what you've got. You have to report everything. So essentially, as a title company, our position would be, we cannot close a transaction until we have complete information on the transaction. And that's going to come as a real shock to our buyers and sellers.
I can only imagine. So, would you be able to tell us more about the compliance deadlines and the filing process?
Sure. So FinCEN has an e-filing system, and reports are to be filed electronically no later than the last day of the month following closing or 30 days after closing, whichever is the earlier. You will need the following in order to e-file: a login.gov account, BSA e-filing system credentials. So once you go to get your login.gov account, I believe that then they will prompt you to get your e-filing system credentials. And then access to the final reporting form, which is a little difficult because, of course, everyone is still working on that form. In less than a month before the rule goes into effect, we don't necessarily have the final form.
Okay. So my next question would be, what if someone doesn't comply with the law?
Well, like I said earlier, non-compliance has serious consequences. The consequence for failing to comply are significant and can increase based upon the nature of the violation. Civil penalties for negligent violations are $1,394 per incident. Willful violations can be up to $278,582 per incident. So if you think you're just going to ignore this, think again, because the government is very serious about this. And then criminal penalties can be up to $250,000 in fines and 5 years imprisonment. So they are very committed to enforcing anti-money laundering matters. So this rule is provides clear standards for what constitutes compliance.
Now, the biggest question our audience will probably have at this point is, what could they do to prepare now?
Well, everyone involved in settlements, escrow, and compliance need to understand these requirements before March 1st. And that includes all staff members of your title office, your settlement office, your law office. If you haven't already, start establishing procedures to identify reportable transactions, because they're not always, it's not always obvious, especially when a file first comes in. Then establish procedures to collect the required information and obtain beneficial ownership certifications. Then create a login.gov account and obtain the BSA e-filing credentials, and develop policies to retain your designation agreements. Now, I didn't really touch on that before, but there is a way, like I said before, there is a list as far as who is the required reporting person. That can be changed by written designation agreement. So if the parties say the title company is supposed to be responsible, but the parties agree that the real estate agent is going to be responsible, that's fine, but there has to be a written designation agreement specifying that, and you have to retain those agreements for up to 5 years. And then periodically check the FinCEN website, which they have a special website to cover all this, to obtain the final reporting form at fincen.gov.rre. And this site also provides a lot of details about this law. If you are planning to shift responsibility for reporting to other parties, you have to make sure your agreements are properly drafted, specific to the single transaction you're talking about. You can't have a global, on all my transactions, I designate somebody else to be the reporting person, and have to be legally enforceable. So, as I said, this rule is the most significant expansion of real estate transaction reporting requirements in, I would say, 40 years. So it brings federal money laundering oversight to hundreds of thousands of transactions that previously had no real oversight on them.
Wow, that seems like a lot of information for our viewers.
Yes, it is. It's a lot to digest. The main thing at this point is for everybody to understand. I've been telling our clients that come in here with cash transactions, hard money lender transactions, private lender transactions. I've been just telling them for the last few months, hey, if a lot of things are going to change come March 1st, and there's going to be a lot more difficulty, a lot more information necessary. So main thing is just to be aware that it's required and that it's out there, and to seek out legal advice as far as how you can make sure you're in compliance. The title, I do know, for example, the company that creates the software for our title company is just installing this week onto our title company's software program, a FinCEN module. And we'll be getting training on that as far as how to enter all this information. So if you're working with the title office after March 1st, you need to make sure that they are complying with this law.
Right. Well, Gayleen, we appreciate you for all your time, all of the detailed information, and I'm sure that viewers will be able to watch this and get more information and possibly come to you for assistance if they needed it.
Absolutely. And of course, this podcast will be on our YouTube channel and available to view at any time. And we've already done one article. We'll be doing follow-up articles as this develops. So thank you, Charlene, for joining me today. And I guess that's it for today for our podcast. Enjoy the rest of your day.